Welcome everyone to the Judiciary Committee agendas for this morning, this Thursday morning, February 2nd. Second or third, oh sorry, February 3rd, I apologize. My name is Carl Rhodes, I'm chair of the committee. This Zoom meeting and YouTube live stream event will include two agendas, the 9:25 decision-making only agenda for bills that we've heard already, and then a 9:30 a.m. Agenda for bills that we'll be hearing today. The other members of the committee are Vice Chair Ke'o Kalole, Senators Ocasio, Gabbard, Lee, Kim, and Favela. I believe Senator Ocasio may have an excused absence today, although she may be able to come late. As noted, this hearing is being streamed live on YouTube. You can find links to viewing options for all Senate hearings and meetings on the live and on-demand video page of the legislature's website. If you're interested in seeing the written testimony, you can go to the legislature's website, which is capitol.hawaii.gov, capitals with an O. In the unlikely event that we have a major technical meltdown, the committee will reconvene to discuss any outstanding business on Friday, tomorrow, February 4 at 9:26 a.m. and a public notice will be posted on the legislature's website. For everyone testifying remotely, all testifier audio will be muted and video disabled until it's your turn to testify. There is a 2-minute time limit on oral testimony. However, members often have questions, so if you can stick around, you may get questions too. If there are temporary technical glitches during your turn to testify, we may have to move on to the next person, but we will try to come back to you if the technical problems are resolved. And I believe that's it. So let's go ahead and start on our 9:25 agenda, which is a DM only agenda. Senator Kim, thank you for being here. I think we don't have quorum just yet. So let me...
Chair, I'm here.
Oh, you're here. Oh, okay, great.
Yep.
So that's 3. We need 1 more for quorum. I will skip over the first item then, which is 6:25, and I would like to vote on today. And I'll go to, okay, now we do have quorum.
Chair, you have quorum.
I won't skip over the first items. SB 629 is the first item up. This allows primary caregivers qualifying out-of-state patients and caregivers of qualifying out-of-state patients to access the restricted access area within a medical cannabis retail dispensary. Our recommendation here is to pass with some amendments. Having consulted with the previous chair of health, who also happens to be the vice chair of judiciary. Recommendation is to go ahead and use the language that the AG's office suggested. Basically, what it will do is instead of allowing more people into restricted access areas, it will create waiting rooms for those people to sit in and leave the restricted areas still restricted. And there will also be some conforming and technical amendments. Any questions, concerns on that? If not, Vice Chair for the vote.
Members voting on SB 629, the recommendation is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard. Is excused. Senator Kim.
Aye.
Senator Lee. Is excused. Senator Favela.
Aye.
Chair, recommendation adopted.
Great, thank you very much, members. Moving on to SB 1211, this repeals the law relating to exemptions for vehicles designated as vehicles used by farmers. I'm gonna defer this a little longer. We're the last committee on this bill, so still trying to work out some language. So we'll defer it until Thursday, February 10 at 9:25, and we'll put up another notice anyway. Deferred until February 10, 9:25. Okay, let's see what time it is. We'll have to wait a minute until we go into the next, our 9:30 agenda. Well, maybe not even a minute, but we'll have to wait a little bit here. So I'm not going to bother to gavel out because it's literally 9:29 now, so it should be just a matter of a few seconds. Wow, a minute can seem like a really long time. Oh, there we go. 9:30 it is. All right, so moving on to our 9:30 agenda for the Judiciary Committee. First up on the 9:30 agenda is SB 2210. This requires the Chief Election Officer with assistance from the county clerks for elections that involve county offices and countywide ballot issues to publish and distribute a voter's pamphlet. First up on SB 2210 is Reese Nakamura, Deputy Attorney General for the AGs. They submitted.
Good morning.
Oh, there you are. Okay, go ahead.
Hello,
Good morning.
I'm Deputy Attorney General Patricia O'Hara, appearing for the department. And we had some concerns about the bill as it's written right now, that there were some internal inconsistencies. So we offered some suggestions for that. And I'd be happy to answer any questions. Thank you.
Great. Thank you. Next is Scott Nago, Chief Elections Officer.
Good morning. The Office of Elections stands on its written testimony providing comment, and we'll be happy to answer any questions.
Great. Thank you. Next is Janet Mason for League of Women Voters of Hawaii.
Morning, Chair. The League supports this bill, but we recommend considering relying primarily on electronic voter information pamphlet because of the cost considerations. It's pretty expensive to print and mail out a written paper voter pamphlet. It could be arranged that voters could, anyone who needed a voter pamphlet, a paper one, could request one. And we note that the Office of Elections has greatly ramped up their electronic voter education, which we think is a good idea. Thanks for your opportunity to testify.
Thank you. Next is Sandy Ma, Executive Director for Common Cause Hawaii. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We support this bill, SB 2210. We provided some guidelines in our written testimony for a fully neutral and fair voter information guide. But we do want to raise a concern that we did not set forth in our written testimony. It has to do with starting on page 8, section 11-G for candidate statements. We're kind of a little bit concerned about candidates being allowed to submit their own statements and then having the Office of Elections review the statements for fairness and accuracy. That may be a stretch for the Office of Elections, and a concern that the Office of Elections can decide what is fair. So that is our further concern with this bill. Otherwise, we do support voter information guides and making them neutral and making them accessible for everyone. Thank you for letting us comment in support of this. If you have any questions, I'm available. Thank you.
Great. Thank you. Next is Craig Hawai'i, Director for Department of Budget and Finance with comments. Jade K. Fountain Tanigawa, County Clerk for the County of Kauai with comments. Susan Roberts Emery, Co-Chair, testifying for the Green Party in support. Barbara Best in support. Liz Wynn Eller in support. Nanea Lowe in support. Susan Durson in support. Will Karen in support. David Anderson in support. And Raiden Iwamoto in support. That's all the testimony we have on this one. Members, questions for those who were here to testify?
I have a question, Chair.
Sure, Senator Kelly.
Yeah.
Hello?
Yes.
Yeah, hi, Mr. Nago. So, okay. I think I understand, but can you explain to me why you estimate that the primary voter pamphlet would be 500 pages long?
So we're looking at one, we estimated roughly 320 candidates per primary and general election. So we're looking at about 1 page per candidate. And then other information such as the how to vote and things that additional pages. That's why we're estimating roughly 500 pages.
And then aside from the translations, how many, would it be just one standard pamphlet, which includes voter information for every race that would be sent to all voters, the same copy?
That's the way we read it. It would be a statewide pamphlet. Certainly, if you were to cut it down by county, it would cut down the cost
Would it complicate
For
the
translation.
production? I mean, I'm not necessarily sure Oahu voters would really think it necessary to have the county candidates for all of the other counties included in their pamphlet.
Yes.
Right.
So our understanding of the way the bill is written is it would be one pamphlet for statewide election. But like I said, if we do change it to countywide, it would cut down the cost substantially. Not substantially, it would cut down the cost.
Okay, thank you. I have another question for Common Cause, but I'll defer to others.
Members, other questions? All right, go ahead, Senator Keokalole.
Hi, Sandy. Do you have an, I guess, what you just testified to, I didn't see necessarily in your testimony. Would you support just eliminating candidate statements?
Thank you, Senator. If the Office of Elections is going to be providing a neutral candidate statement, yes, we would support. If Office of Elections is going to be providing a voter information guide on each candidate, yes, then I would support eliminating candidate statements. Because further on in the bill, it provides that the rejection or dispute, it should be made by the chief election officer. I mean,
Yeah, I agree with you. That sounds really difficult and cumbersome. But I'm just kind of, I'm a little stuck on the 500 pages for the pamphlet thing. And if we're going to include, if we get rid of candidate statements, I wonder how significantly that changes what we're talking about. So if that's your position, because I didn't see that included in the testimony, if your position is that there shouldn't be a candidate statement and then we just strike that whole section in the bill, then that's helpful. Thank you.
Thank you.
Thank you, Chair.
Thank you. Members, other questions? I do have a couple, so I'll go ahead, and if other people come up with stuff, that's great. For Mr. Nago, so I guess the way you're interpreting it then is that this is a 500-page thing. Is it? So the reason I'm going that way is so we're all mail voting basically now. So a 500-page document is not something you're going to be able to mail to everybody. Is it technically feasible to tailor each? To take a piece of that 500-page overall pamphlet and then send the ones that are relevant to the races that that individual voter is voting on and just send them, I don't know how many pages it would be, but 3 or 4.
Yeah, so you would still have the candidates for that ballot, but you would still have the other part, the how to vote, the mechanics of voting. You would still have that part. So it would bring it down substantially if you were to just tailor it to the voter. But I think if you follow the League of Women Voters suggestion, if you really wanted to bring the cost down, you would have it digitally, because that way the cost would be limited basically to translation.
Yeah, I understand that argument. I guess I'm a little, well, I mean, I represent, a number of us represent districts that have at least parts of them are quite poor, and I just don't know how much digital literacy there is for some people who are kind of marginal voters anyway. But technically, if it was, we're going to send the pages that have to do with the names and ballot issues that are on your ballot, you could do that.
Yeah, well, it also would depend on the county, because for Honolulu, we're covered for 3 languages, so we would still have to send that piece of material to the voters in the translated covered languages.
So it's probably more like, I mean, just a guess, 9 or 10, 12 pages that you would have to put in there in addition to the instructions.
It depends on how you lay it out and how big you want to print.
Yeah. Okay. All right. Members, any other questions?
I do.
Senator Kim, go ahead.
I noticed that, Scott, that you do have the cost for mailing, but is it based on how heavy? I mean, the 500-page?
Yeah, it's based on the 500 pages, and it would be a mailing that's not done with the ballot because it wouldn't fit in the ballot packet. So it would be an individual mailing via nonprofit, which ballots are not mailed.
Okay, and if this would go into perpetuity in the sense that it's not just for this upcoming election, right? It would be for every election?
That's
So
the way we rated the bill.
the
Yeah.
cost of postage and so forth and handling, because they keep adding more things that you gotta tab it, you have to do all kinds of stuff to it. Do we have any kinds of idea as to when somebody receive a 500-page booklet like that? You know, what's the chances of them actually reading it and looking at it? And
I mean, I can only speak from my experience. When I get those annual reports for stocks, I go straight into the trash can. So I don't know if somebody
Do
would
the
actually
same
go
thing.
through the 500.
right, I'm just wondering as to, and then I know there's a lot of, when I go to the post office and get my PO box, I see all of that into the trash. A lot of the booklets and everything, it just goes straight to the trash can. So I just want, you know, as for the investment and the cost, and I know we want to educate the voter, but again, what the costs and whether or not a pamphlet of that nature is educating the public, other than a list of the candidates that the press actually will print before the election. So, okay, thank you for that. Thank you, Mr. Chair.
Thank you. Members, any other questions? Senator Lee, go ahead.
Oh, Jerry can go. I just saw him. Oh, well, thanks, Chair. I just want to say the thing that I love the most about my youth is getting that 500-page Sears catalog in the mail every Christmas and spending the next like 18 months dreaming about it. I'd love to have all your fine faces staring back at me in the same way, but maybe there's a way to like split the difference here. Notwithstanding, I think, Chair, your concerns about like folks who are digitally illiterate. Obviously, there's going to be no way digitally to address that. But if you were to mail, for example, even just a single page that had the basic link or maybe QR code to your personalized web page for all the people that are on your particular ballot, it's then just a regular mailing cost. But then you still can personalize in a way that, at the very least, for some people, or maybe even, you know, half or so, just having that, here's your folks that you can vote for, you know, take a look. I don't know, maybe that'd be still helpful. I'm just throwing that out there. Thanks, Chair.
Thank you. Senator Keokalole, you had another question? Go ahead.
Yeah, I think I'd like to start by putting that suggestion into a question for Mr. Nago. But I guess the other thing would be, if we're gonna, if the idea to personalize the pamphlet in the hopes of reducing cost and making the pamphlet itself more relevant, you know, I think the filing deadlines are in May, and then because of all mail, the ballots actually hit doors somewhere in the middle or end of July. Would your office even have the capacity to compile that type of information in time to get it to voters with a meaningful amount of time before the ballots are in front of them, including whatever sort of constitutional or charter amendments might be, I assume, included in something like this?
So it would just depend on when the deadline is to get the statements, the candidate statements. If it's done at the candidate filing deadline or at the time of filing, we could do that. As far as charter questions and constitutional amendments, that would be for the general election. The deadline, I believe, is 75 days off the top of my head prior to the election, so we would have time to do that. And then for the general election with the candidates, we would just carry it forward from the primary with the winners. So we could do it. It just depends on when the statements are due.
Okay, thank you. This is not the AG doesn't need to answer, but I would be interested in whether a pamphlet like this with information about charter and constitutional amendments would cure the court opinion related to the last constitutional amendment that was overturned. We don't need to get into that at this point. I'm just thinking out loud. Thank you, Chair.
Thank you. Members, other questions? Okay, for Mr. Nago, I don't know how carefully you've looked at this, but page 10, line 5, it says that a candidate will be able to challenge information about a ballot initiative. Is that seems odd to me. I can see where they would want to be able to challenge something that was said about them, I'm sorry, page 10, line 5 is where I saw this.
So I believe it just says the candidate may petition the circuit court for a rebuttal or argument for the statements.
Right, but it sounded to me, okay, but you're reading it somewhat differently than I was then, because it looked to me like they could challenge the ballot. The statements about ballot questions too, not just their own, not just candidate statements.
Oh, I read it as there's a statement against them if their opponent does the defamatory information.
Okay. Well, that in and of itself is concerning if two people are reading it differently. So, okay. For Janet Mason, if you're still here, for League of Women Voters. No, I see your name still here. If not, Sandy Ma, are you still here? Oh, there you go. Thanks. So on the requirement that a fiscal statement be attached to the ballot initiatives, I guess the thing I worry about there is, I think it's a good idea actually, but are you aware of any other jurisdiction that says, you have to put not only the fiscal statement for whatever it is, if you vote yes, but the fiscal impact if you vote no? Like what harm are we trying to avoid by spending this money?
Thank you, Chair, for that question. I understand California, for bills introduced, that there is a fiscal analysis for each bill. And so I think that's trying to, mirror that.
Are you aware whether the California bill says, or the California requirement says anything about what happens if we just don't pass the bill or don't pass the ballot initiative, and how much is it going to cost?
I am not.
You don't know. Okay, that's fine. That's fine.
I can find out.
No, we can find out. I was just curious if someone knew.
Thank you.
All right, I think that's all the questions I have. Anybody else have anything? Okay, if not, thank you very much, testifiers. We'll go ahead and move on to the next measure, which is SB 2178. This proposes an amendment to Article 2, Section 1 of the Hawaii State Constitution to change the age qualifications for voting in state or local elections. Would make it so that if you're going to be 18 by the general election, even though you'd be 17 at the primary, you would be able to vote in the primary. First up on this one on 2178 is Janet Mason, League of Women Voters.
Thank you, Chair. The League supports this bill, and we have one question or a suggestion, and that is perhaps amending the language of the bill to clarify that the person can both register to vote and vote during these primary elections, because it isn't entirely clear that, registration as well as voting is allowed.
Okay, thank you very much. Next up is Sandy Ma, Executive Director, Common Cause.
Good morning, Chair, Vice Chair, members. Sandy Ma for Common Cause, Hawaii. We stand on our written testimony in support of this proposed constitutional amendment. Thank you.
Thank you. Next is Susan Roberts Emery, co-chair for the Green Party in support, Ann Freed in support, Vote Hawaii, Vote 16 Hawaii with comments, Marilyn Yamamoto with comments, Shannon Rudolph in support, Liz Wynn Eller in support, Susan Durson in support, David Anderson in support, Cynthia Reeves in support. That's all the testimony we have on this measure. Members, any questions for those who are here? Okay, I don't see any. Let me see if I have any. Nope, I don't. Let's go ahead and move on to the next bill. That would be SB 2162, which would establish ranked choice voting for special federal elections and special elections of vacant county council seats. First up on 2162 is Janet Mason, League of Women Voters. Morning again. Can't hear you.
The League supports this bill. This is the first time we've provided anything except comments And the reason is that we're now pretty encouraged that voters would be able to understand such a ballot based on research in other locations. We suggest amending the bill to limit the number of voters that could be included with write-in candidates, just to avoid ridiculous number of write-in candidates that have to be ranked. And we wonder if the bill needs to take into account the rights of political parties in Hawaii, in particular minority parties, small parties who might be eliminated during the subsequent ranking, but would care to know how many votes they received. So we know that Maine has a provision in their bill that provides that the number of votes received by different political parties would be the ones cast in the first round.
Okay, thank you. Next is Sandy Mott, Executive Director of Common Cause. Morning again.
Good morning again, Chair, Vice Chair, and members of the committee. Sandy Mott for Common Cause Hawaii. We support SB 2162, establishing ranked choice voting for a limited number of races, just for special federal elections and special elections of vacant county council seats. We think this is a great measure to establish ranked choice voting in Hawaii. And I'm available to answer any questions about ranked choice voting and how it could benefit democracy in Hawaii. Thank you.
Great, thank you. Next is Brianna Harmon for sorry. Good morning.
Hi, good morning. My name is Brianna Harmon. I'm a high school senior, actually, and I'm testifying in support of this bill because I think it will allow for more competitive elections that aren't focused on degrading the other candidate and more on appealing to the voters. And I think that ranked choice voting allows for candidates to vote for people who they think will truly represent them and not just candidates that they think can win. Thank you.
No, thank you very much. Thanks for being here. Next is Susan B. Roberts Emery, co-chair Green Party Hawaii, in support. Gary Hoosier, Executive Director of Pono Hawaii Initiative, also in support. Michael Galoyu, Senior, in support. Barbara Best, in support. Kawanoi Batangan, in support. Liz Wynn Eller, in support. Nanea Lowe, in support. Susan Durson, in support. Will Karen, in support. David Anderson, in support. Daniel Freund, in support. John Bickel for Americans for Democratic Action, in support. And Gerald Gorner, in support. And Rob Ritchie, President and CEO for Fair Vote Action, in support. Members, that's all the testimony we have on SB 2392. Any questions? I do have a question for, I think it was League of Women Voters. Were you the one that raised the issue of how many votes the so-called minor parties get?
Yes, yes, Chair.
So normally the rule is that if you get a certain, I forget what the percentage is, a certain percentage in the general, then you get to go on the ballot in the next election cycle too.
All right.
I don't know. I'm asking.
I mean, my point is simply that if you're a minority party, for instance, the American Shopping Party, you're interested to report to members of your party how the party did in the election. Mm-hmm. And you should be able to use the first round tally to do that, not necessarily the results of the final action. That's,
okay, so you're assuming that those initial rounds wouldn't be reported as part of the Office of Elections tabulations?
I don't know, but as a safeguard, we think it is fair to make sure that the tabulations of the parties are included, all the parties, and that if a member of the public asks, how did the party do in the election, they'd be provided the results of the first round.
Okay. Okay, thank you. Okay, members, any other questions? All right, seeing none, thank you, those of you who came to testify for weighing in on that. Next up, we have SB 2392. This appropriates funds for the judiciary to purchase civil legal services for low and moderate income persons. Let's see, 2392. First up on 2392 is Rachel Figueroa, Executive Director for Volunteer Legal Services of Hawaii. Good morning.
Good morning, Chair, Vice Chair, and members of the Committee on Judiciary. My name is Rachel Figueroa, and as you said, Executive Director of Legal Services Hawaii, testifying in support of SB 2392. Volunteer Legal receives no federal funds and has been grateful for some funds like IOLTA, ILAC, and private donations. However, this was not enough to sustain us throughout the year, and we have been dipping into our reserves. Despite the limited funding, we thankfully have been able to continue virtually qualifying and serving over 1,000 clients last year, with just a staff of 7. Thank you for the consideration of this critical appropriation to assist in continuing our services as we emerge from the pandemic. Thank you for your time again. I'm available for questions afterwards.
Thank you very much. Next is Nalani Fujimura Kaina, Executive Director, Legal Aid Society of Hawaii.
Aloha, Chair and members of the committee. Mahalo for this opportunity to testify. My name is Nalani Fujimori Kaina. I'm the Executive Director with the Legal Aid Society of Hawaii. Our organization is the largest organization to provide civil legal services in the state. In 2021, we actually received over 19,000 requests for services, and we're able to assist 8,200 with their civil legal needs. Our assistance is related to family housing, consumer foreclosure, public benefits, elder law, homelessness, immigration, language access, and child welfare. We wanted to ask for support of the state for $750,000 in an allocation through the purchase of service contract through the judiciary. This amount represents the last amount provided in fiscal 20, which was prior to the pandemic. And represented the amounts that were allocated for the judiciary for purchase of service, as well as a grant and aid for us directly for $250,000. It is critical and important for our organizations and organizations like ours to have general civil legal services funds available so that we can be flexible during times like the pandemic. We were fortunate during the time of the pandemic to have federal resources to come in addition to PPP loan funds and also foundation funding to keep us going during this period of time and to provide the services that we have. So thank you again for this opportunity to testify and happy to answer any questions that the committee may have.
Great, thank you. Next is Rodney Miley, Administrative Director for the Judiciary in support. Craig Harai, Director, Department of Budget and Finance with comments. Giovanni D. Dela Cruz for Hawaii Office of Community Services in support. Joanne Hoya for Volunteer Legal Services Hawaii in support. Trevor Assam in support. Tread Airley in support. Melissa Miyashiro in support. Robert J. Leclerc, Executive Director, Hawaii Justice Foundation in support. Amy Agbayani, Filipina Advocacy Network, FAN in support. Corey Park for the President Legal Clinic in support. Corey Park also for the Legal Clinic in support. Joseph Cardoza, Hawaii Access to Justice Commission in support. And Kathy Betts, Director for Department of Human Services, State of Hawaii, also in support. Members, any questions for the 2 testifiers who came today? Okay, I don't think I do either. Let's see. Nope. Okay, thank you for being here, and we'll go ahead and move on to SB 2406 relating to special purpose revenue bonds. This defines the terms public interest with regard to the issuance of special purpose revenue bonds. First up on 2406 is Craig Harai, Director, Department of Budget and Finance with comments, and Shannon Rudolph in support. No one asking questions of, so we'll go ahead and move on to the next bill, which is SB 2486. This proposes an amendment to several amendments to the state constitution to make the legislature a year-round enterprise. First up on 2486 is Sandy Ma, Executive Director, Common Cause.
Good afternoon. Oh, sorry. Good morning, Chair, Vice Chair, members of the committee. Sandy Ma for Common Cause Hawaii. We support this proposed constitutional amendment, but we do think it deserves more time and thought given the number of sections affected by the Constitution, affecting the Constitution, and how it will change our how our legislature is run. So while we do support this, we do think more thought and consideration should be given to this measure. And I'm available for any questions. Thank you for allowing Common Cause to testify on this measure. Thank you.
Thank you very much. That's the only testifier we have on this measure. Members, any questions? I have a question, sort of a general one. So I agree that there's a lot of moving parts and very difficult bill in many respects. But why do you think that having a full-time legislature is better than having, I mean, most states, especially most states our size, have part-time legislators and laters too?
I think given the number of bills that are introduced and the fast pace of the session, it is difficult for people who want to get involved in the civic process to understand how to get involved in the civic process. There are a lot of resources out there, both provided by the public access room and even by nonprofit organizations such as Common Cause and League of Women Voters and others. But still, it is hard for people who work full-time jobs to be able to understand and to navigate the legislative process when it's in session and when it's so fast and there's so many bills. So maybe having a full-time session throughout the year could allow more people to get involved and follow better the timelines and to testify more fully and to have more reasoned considered decision-making of the legislators themselves. And so that is one thought or two.
Okay. So, but that would make us, I mean, this is a without judgment question. So that would make us more like the city council, although city council, of course, has the added restriction of the sunshine law applying to them. But you feel like the city council has better or deeper community involvement than the legislature does?
I wouldn't say that. It's just different. Their bills don't, my understanding, have a longer time to move through the process, and so which is different than the state. And so it's just a different process. I'm not saying one is better than the other. I'm just saying it's a different process and it's a consideration.
Okay, thank you. Members, any other questions?
I do.
Yes, Senator Kim, go ahead.
Thank you, Sandy. Thank you. Having served on the city council, I'm not so much that it's a different process, but the fact that you talked about participation and people understanding the process better. But I found that on the council, not necessarily that happens. It's just, we wait to the last minute to do something on the council, no bill dies. It keeps coming back. So again, I'm not sure how that would work on as far as more people being involved.
That's definitely true. Thank you, Senator, for raising that point. So that's definitely something to consider, that it maybe extending it, having a year-round state legislative session may not improve civic engagement and access, but the city council is for Honolulu, and the state legislature is statewide, and we hope that people on the neighbor islands would be able to become more engaged in the state legislative session if it's statewide. I don't know. That's something for consideration. And so that's why this proposal should merit more attention and consideration. Thank you. Thank you, Senator.
One thing you might want to consider too is having a year-long, and I'm torn between it myself, but having a year-long kind of legislature, do you think that gives more to the lobbyists and those people who have the funds and the money that they can sustain you know, having year-round kind of staff that'll be consistently at us compared to the average person out there who you want to be engaged, yet don't have the kinds of resources that these special interest groups would have?
You know, that's definitely something to consider, but also people average, the public is engaged year round too. And so that's something to think about too. And so I'm sure you meet with your constituents year round and they have concerns year round. And I hear, why is the legislature being paid X amount of dollars, but they only work, you know, 5-6 months out of the year? And so that's something I have heard too. But there's pros and cons and things to discuss with this proposal that I think is worthy of further discussion.
I guess I don't, not being in session all year long doesn't necessarily mean that we don't work all year long.
I know.
Being in session doesn't necessarily mean you're not engaged all year long. So I'm not sure how that image or that, you know, sense can be changed, that people realize that we are engaged all year long. You don't have to have a session to be engaged. So anyway, thank you, Sandy. Appreciate your comments.
No. Oh, no, thank you. Thank you, Senator. Thank you.
Thank you very much. Any other questions? All right, if not, we'll go ahead and move on to SB. Thank you for being here, Ms. Ma, for SB 2377 relating to state tax examinations, establishes a penalty for failure to respond to inquiry or request during a state tax examination. The only testifier on SB 2377 is Director Choi for the Department of Taxation.
Thank you, Chair. Thank you for allowing me to testify on this measure. Just some additional comments. One, paper chasing at the department is just costing us a lot of time and overhead. My second comment is there is a corresponding criminal statute, 231.35, that for willful failure to supply information. I believe I'm the only director that's now initiating action on a criminal basis for not supplying us information. I'm finding that a little heavy-handed, and of course the paperwork on that one is just unbelievable. This will establish a civil penalty. I think a civil penalty is the right way to go. Thank you very much for allowing me to testify, Chair.
Thank you for being here today. That's the only testifier we have on SB 2377. Members, any questions? So let me just follow up on what you said, Director. What you say you have. Does the underlying investigation have to be criminal before you can pull out the criminal penalties for not responding, or can it be a civil investigation and you still have to pull out the criminal penalties?
It does not have to be a criminal investigation.
Okay.
It's just a failure to supply information.
Okay.
Yeah.
So the only recourse you have right now is sort of a nuclear option. Exactly. Okay. All right. Understood. Thank you. Members, any other questions? Okay, seeing none. Thanks, Director, for being here. Next up is SB 2663. This relates to filing fees for paternity actions. It would establish an initial filing fee of $100, and it would eliminate fees for filing motions later on in the process. On 2663, we have Melody Aduha for the Health Committee of the Democratic Party of Hawaii in support. We have Nancy Creedman for the Domestic Violence Action Center also in support. Neither one are here, so we will go ahead and move on to the next bill, which is SB 3041. SB 3041 makes appropriations for claims against the state. First up on 3041 is Karen Inagaki, Deputy Attorney General. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Karen Inagaki, Deputy Attorney General. The bill currently contains 8 claims for a total of $938,613.47. All of these claims are general fund appropriation requests. And there is an attachment A to our testimony that describes each of these claims. And we would ask that this bill be passed with the understanding that there may be additional claims that we will ask to be added to the bill. I will be happy to take any questions. Thank you.
Thank you. We had one further testifier, Craig Harai for Department of Budget and Finance with comments. And that's it. Members, any questions for Ms. Inagaki? I have a couple. Hang on just a second. So one of the miscellaneous claims was to pay a Princeville Hotel $383,199.65 for an outdated check. Any idea how somebody doesn't cash a check of that size for until it's expired?
You know, we've seen this a lot. I mean, that is a logical question, but there are a lot of corporations where that is not a lot to them. And so, you know, it does fall through the cracks, and they usually have someone else, you know, going through their records and realizing that they never got a tax refund check. So it's not that unusual, but it's because these are corporations that have a lot of money. So it's not something that like to the average person, of course, you know, we would never let that go. But I think with corporations, it's a little bit different.
We don't pay interest on that, do we?
No.
In fact, okay, so it's just however long ago it was, it's the same dollar amount.
Right, we're just reissuing the check.
Okay. There's also a claim for settlement involving the Agribusiness Development Corp to pay the second half of attorney's fees and costs that was awarded by the court. Why did we only pay half of that? And now we are paying interest on it. Why did we only pay half of that in 2021?
I think it was because of the dollar amounts, that it was just too much to pay at one time. So they split the attorney's fees so that it would be more palatable.
I mean, how much money were we talking about there? I don't have the I mean, for the state to pay that amount? I mean, it doesn't, we're not that cash poor.
Well, I think it was a decision reached in the settlement because the amount was fairly significant. They wanted to not have to pay it all at once. So they just split it in half. And then the second payment does have a little bit of interest attached to it.
I mean, I guess it's the interest that bothers me the most. It's like we had the cash, we could have paid it. It's just why would we want to pay interest? I mean, I realize the price of money is low right now, but still. Okay, I'm sorry, I'm going on and on. Members, any other questions? I have a couple more. Okay, there's a settlement of a wrongful death claim involving the Department of Public Safety, where an individual was released from prison at night with disposable clothes, no money, no ID, and they did not give him his medication, which was apparently necessary for the condition he had. 8 days later, he was found dead. Is this a typical release from PSD custody?
Well, I'm not going to speak for PSD, but from what I understand of this case, no, it is not. And there was just some confusion about when they were going to release him. He was supposed to have been released earlier. They didn't think he was going to be released until the next day, but I think there was just some paperwork mix-up, and then when they realized that he should have been released and they didn't want to over-detain him, that was when they released him. So it was a very unfortunate, unusual mix-up that resulted in this situation.
Well, I hope it was unusual, because no clothes, no money, no ID. I mean, that's just, we're lucky to get out of that one for $150,000 would be my opinion. Is there what are you advising them on corrective action for that so that doesn't happen again?
Absolutely.
Has that already been given, or is it something you're planning to do?
We've sent it out. We have not received a response.
Okay. Then usually, at least for the last few years, the standard operating procedure for the legislature has been to require that the agency that lost the case pay it out of their own budget, and you're asking for general funds here. Is there a reason for that?
We always ask for general funds because the departments are always cash strapped, and they ask us to at least request that it be appropriated out of the general funds. There is one claim, the charter school claim, where they really do not have any additional funds because all the money goes towards the students. and to run the school. So, you know, they traditionally have no money at all. So we've had a few claims in the past where the charter schools couldn't pay it when they were told to pay it out of their own budget. So we had to keep coming back to the legislature because there just was no money. But I think as a general proposition, you know, all of the departments have difficulty because they don't have a lot of funds to pay for claims. So that's why we always ask, at least initially, that they be paid out of the general funds.
It seems to me then departments that get sued a lot ought to ask us for money for a sinking fund for claims, because you understand what I'm saying. I won't go there right now. I wanted to ask you about the Calpico case too. It was not clear to me why the state got stuck paying for anything there. So if there was somebody out aquarium fishing when they weren't supposed to be, when there was an injunction against it, why is the state on the hook for anything? No pun intended.
I don't have a lot of details on this particular claim. It's just that when we lost the appeal, that's usually where it happens, you know, where that there were several issues, but we did lose on one of the issues. And
what were we even sued for? I mean, why would we be sued?
I think it was related to the statute, that they claimed that there was some problem with the statute. And, you know, Senator, I don't have a lot of information on this particular case, so I will, if you have additional questions, I can get back to you after I've
If you could just send us enough information so we know, to me is fine, is why, because I could understand why somebody might sue somebody for violating the injunction, but I don't know, unless the state was telling people, even though the injunction was in place, that they could go ahead and fish, then maybe we get named. But otherwise, it seems like it would just be between private parties I'm just not quite sure why we're involved, and that's what I'd like to know.
I will check with the division that handled this claim, and I will get back to you.
Okay, I appreciate it. Lastly, so there's a check for $40.65 to Sang Chol Bong, a reissue, which is fine, but do we really need it? Is there no process for dealing with minor reissue checks like that? Does that really need to be part of a bill?
There is no other way to pay for these outdated checks. As far as I know, this is the only way to get the checks reissued, because the DAGS only has so many years to reissue the check. When they can't do it, they send it over to the attorney generals, and in the statute, we bring it before the legislature for approval.
Okay, all right. Okay, that's all I've got. Members, any other questions? Thank you. Thanks, Ms. Inagaki, for being with us today. Next and last is SB 3046, making an emergency appropriation to the Department of the Attorney General for retention of expert witnesses and specialized legal counsel in major litigation against the state. First up is John Price, Deputy Attorney General. Good morning.
Morning, Chair Rhodes and members of the committee. I'm John Price, Deputy Attorney General. We, of course, are in support of the bill. And although it seems like a lot of money, probably, it's money that should be looked at more as an investment than an expense. Expert witnesses are very helpful. Any of you who have litigation experience probably know that as well as I. They either help keep the damages down or help win on liability outright. We have some very high dollar exposure cases in progress now that require sort of extraordinary expense on the expert side. As the investment people say, past results is no guarantee of future performance, but we have had good results with expert testimony in recent past cases. We had a failed computer system implementation case in which we started out as the defendant being sued for several $1 million in 8 figures. And by the time we got finished with our excellent expert guidance on a few different subject matters, we recovered 31 million from the defendant. They turned into the defendant. The plaintiff who sued us paid us. So it's an investment, and I think it's money well spent or invested to protect the Treasury.
Okay, thank you.
Thank you very much.
The other, if you can hang around for a second for questions, there's one other testifier, Craig Hawai'i, Director, Department of Budget and Finance, with comments. And that's all the testifiers we have on SB 3046. Members, any questions from Mr. Price? I did have one. Two of the cases that you mentioned in testimony, the Dannenberg, which is about UTF obligations, and the Kalima case about DHHL. I mean, on their face, it sounds like something where the state might be wrong. How do you go about this in terms of, I mean, in the civil litigation world, it would just be scorched earth, and you would just fight for every penny. And yeah, usually they settle eventually, but it's pretty hard nosed. Is that the same sort of paradigm that the state uses in cases like that, or is this more of a search for a settlement and a search for justice?
The latter. It's a search to come up with the right fair number.
Okay, so
not have to overpay, but it's certainly not an exercise in trying to claw back or minimize payment. We want to make sure that the payments are exactly what folks are entitled to.
Okay. Okay. Thank you.
Thank you.
Other questions, members? If not, thanks, Mr. Price, for being here. So that's the end of the agenda. Let's see, members, unless people, if there's anything that people, members want to discuss, I'm ready to go ahead and just do decision making as long as we have quorum. Everybody okay with that? Yeah, we have quorum. I think Mike's here too. Okay, we'll go ahead and go straight to decision making. First up is SB 2210. This requires the chief election officer, with assistance from the county clerks for elections that involve county offices and countywide ballot issues, to publish and distribute a voters pamphlet. I'm going to ask the committee to move this along, but I'll put a bad date on it. July 30, 2075. And there are some technical amendments as well. And I have a long list of amendments, and we'll move it forward and see. And it's definitely a work in progress. I think the idea at some level makes a lot of sense, but there's a lot of things that are difficult to work out. So I would ask the committee's indulgence to let us move it ahead, but with a bad date. So here are the suggested amendments. Add an amendment suggested by Kauai County to give counties the same liability protections as the state. I already said, change the effective date to July 1, 2023, and the implementing, let's see, I don't know how that works with the, well, I guess we'll just put in the committee report that we anticipate that this would not go into effect until the 2024 election, but we'll put the bad date on it, so there's no question about whether it can go into effect like it is. And we'll put in the committee report that the Office of Elections says that they will need 16.3 million to run the program in the next biennium, and we'll take out the blank appropriations because it wouldn't be any if the bill were to pass this cycle. Require that any fiscal statements estimate how much not passing the ballot initiative is likely to cost using the same time frames. And the pamphlet distribution will fill in the blanks for the different pamphlet distributions. I'm sorry, not for the pamphlet distribution, no later than the day the ballots go out, either with the ballots or without them, depending on how it turns out. We'll take out the provisions that allows a candidate to challenge a ballot measure, because it, or at least clarify it. The Office of Elections was reading it differently, but make it clear that the candidates themselves can't challenge the ballot arguments. And then a petition must be filed no later than 5 days after the deadline of the argument, rebuttal, or candidate statement. Rebuttal statements after the revision of an argument must be submitted within 5 days. If the rebuttal statement has already been submitted, any changes after it changed to the argument must be completed within 5 days. And in response to the AG's comments, we'll have the state or county budget offices prepare the fiscal statements instead of the AGs. So, oh, I'm sorry. And one last thing, and an important thing, we'll tailor the packet to the individual ballot. So that won't, I mean, maybe it would make sense to have a master 500-page ballot that then you could just slice and dice for the specific ballot that someone receives. But this whole notion of sending out a 500-page tome is just, it's not going to work, and it's unnecessary. Besides the fact that no one will read it, it will cost an incredible amount of money. So that's it. So just request to move forward, and we'll see what we can do. Yes, Senator Kim.
I wanted to request that we take out the statement, the candidate statement, and that would take out a lot of issues. It would make it smaller, wouldn't have, you know, anything for them to have to challenge. And the other thing, though, you got to consider when you do it by area, that does involve a lot more in the back room, where they have to collate, have to decide how many, who goes what, you know, what overlapping districts, how that changes. So that consideration, that cost may go up. But I would suggest taking out the candidate statement as we move it forward.
So, but what you're suggesting then, would there be anything about the, I mean, there would be a statement about the candidates written by the Office of Elections? Is that what you're suggesting?
Well, I think they could be, you know, general about everybody the same, you know, background. I'm not sure, but when you do a statement, is it how many words, how many letters in the word? What can they say? I mean, there's going to be a lot of issues as to.
Yeah. If
I wanted to say something opposing the other guy or something nasty. I mean, as long as I don't use foul words, you know, that's my freedom of speech. So I just see a whole lot of can of worms when you do a candidate statement. So.
Yeah, no, there's well, I guess if there's nothing about the candidates, it seems like the whole thing is kind of pointless. I mean, you got to have something. The question is who writes it, and I don't know. I think at this point, let's leave it as is, and I totally understand what you're saying. And if you oppose it on that basis, I can understand that too. But let's leave it as it is for now. But I think that's an absolutely.
Can you include something in the committee report regarding that?
Sure, that there's a serious question about whether it makes sense to put to have the candidates themselves do the statements. Is that okay?
Mm-hmm.
Okay, let's do that. Senator Keough Kalole.
I agree with Senator Kim. I think you know, if you're going to move it and note that in the committee report, that's fine. But I also think in lieu of a candidate statement, I mean, a website address or a QR code to a website would probably cure this in my mind. I mean, this is obviously our first pass at this bill, so I don't have a problem with it moving along. But I agree with Senator Kim. I think we are just asking for trouble with the candidate statements. Although I understand what your
my only real concern about the QR code or whatever is just, I've got a lot of constituents who that just doesn't help them at all. So I don't know. If it's okay with the committee, we'll move it along, but we'll put some language in the committee report about whether that to indicate that more than one member of the committee are expressing doubts about the wisdom of doing that, and that it's a good question about how we should handle that part of it. Okay, anything else? If not, Vice Chair, for the vote.
Members voting on SB 2210, the recommendation is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio is excused. Senator Gabbard.
Aye.
Senator Kim.
I'm going to go with reservations.
Senator Lee.
Aye.
Senator Favela.
Reservations.
Chair recommendation adopted.
Okay, thank you very much. That brings us to SB 2178. This proposes an amendment to Article 2, Section 1 of the Constitution to change the age qualification for voting. It would allow anybody who is going to be 18 by the general election to vote in the primary, even though they'd only be 17 at that point. I thought that some of the testifiers raised a good point about the registration part of it, but the Con-Am itself isn't really the place to put that. So recommendation is to pass it as is. Questions or concerns? If not, Vice Chair.
Members, SB 2178, the recommendation is to pass this measure unamended. With Ocasio excused and 6 members present, members, are there any reservations? Any no votes? Seeing none, all members vote aye. Recommendation adopted.
Thank you. Next up is SB 2162. This establishes ranked choice voting for special federal elections and special elections of vacant county council seats. The recommendation here, again, there was testimony that there was raising questions about whether so-called minor parties should have some sort of trigger for the vote count. I don't think that's going to be an issue because the votes, the tally still has to be given. I mean, the Office of Election still has to give a tally of what happened. So I don't believe that will be an issue. So the recommendation is to pass as is. Questions or concerns? If not, Vice Chair.
Members, SB 2162, the recommendation is to pass this measure unamended. Noting the excused absence of Senator Ocasio, 6 members present, are there any reservations or no votes?
Reservations.
So noted. Chair, recommendation adopted.
Thank you, members. Next up is SB 2392. This appropriates funds for the judiciary to purchase civil legal services. The amount in the bill is $750,000. I'd like to take out the mention of specific providers in the preamble, so as not to prejudge who would get the money if the bill passes, and that would be the only amendment. Questions or concerns? If not, Vice Chair.
Voting on SB 2392, the recommendation is to pass this measure with amendments. With Senator Ocasio excused and 6 members present, are there any noes or reservations? Recommendation adopted.
Thank you. Next up is SB 2406 relating to special purpose revenue bonds. I'm just going to defer this until, let's see. Let's go ahead and defer it until Tuesday, which I don't know the date of. Anybody know the date of Tuesday?
8th.
8th? Okay. February 8th at 9:26 a.m. And we'll do DM then. Next is SB 2486. This is a proposal to amend the Constitution to make the legislature a year-round endeavor. I do think it's an interesting idea in many respects. When the original, when the Constitution was written, the state was a lot smaller, and I think it was much more manageable to do it in a part-time legislature. Having said that, it's a complicated issue with lots of problems, so I'm going to defer this one indefinitely. Next up is SB 2377 relating to state tax examinations, establishes a penalty for failure to respond to an inquiry or request during a state tax examination. Recommendation here is to pass as is. Questions, concerns? If not, Vice Chair.
Members, SB 2377 passing unamended. With Ocasio excused and 6 members present, are there any noes or reservations?
Reservations.
So noted. Chair, recommendation adopted.
Thank you very much. Next up is SB 2663. This changes the filing fee schedule for paternity actions by establishing an initial fee of $100 and then eliminating fees for subsequent motions that need to be filed. The recommendation here is to pass as is. Questions or concerns? If not, Senator Keokalole.
Members, SB 2663 passing unamended. Senator Ocasio excused, 6 members present. Any noes or reservations? Chair, recommendation adopted.
Thanks very much. Next up is SB 3041. This is the claims against the state bill. Recommendation here is to pass with an amendment. Normal practice has been to require the agency or department or agency involved to pay their own claims. And I realize the charter schools may not be able to, but I'm going to suggest that we change it to the not from the general fund, but from the funds of the agency or department that lost the suit. It goes to WAM next. That's clearly in their Kuleana. If they want to pay it from general funds, I won't object, but I'd like to put that in for now. Questions, concerns? If not, Vice Chair.
Members voting on SB 3041, the recommendation is to pass with amendments. 6 members present. Senator Ocasio excused. Are there any noes or reservations? Chair, recommendation adopted.
Thank you. And finally, we have SB 3046 as an emergency appropriations Department Attorney General for retention of expert witnesses and specialized legal counsel in major litigation against the state. Recommendation is to pass it as is. I think I would like to put in the committee report language reflecting my comments when we were questioning the witness about being sure that we're aiming for justice, not just engaging in scorched earth civil litigation tactics. Questions or concerns? If not, Senator Keokalole.
Members voting on SB 3046, Chair's recommendation is to pass the measure unamended. With 6 members present, are there any noes or reservations?
Reservations.
Reservations for Senator Favela. Senator Ocasio is excused. All of the members vote aye. Recommendation adopted.
All right, thanks members for being here. We'll see you tomorrow. Mahalo.